Now we're joined by two lawyers, Tim Danson and Karen McArthur. Tim is the lawyer for the Stevenson family, whose 11-year-old son Christopher was murdered by a convicted pedophile and psychopath. He is pressing Allen Rock to enact a law which calls for violent sexual predators to be held in jail indefinitely. Karen is the former lawyer for Keith Leger, a convicted pedophile. Thank you both for joining us. Tim, let's start with you. If you can briefly explain how this law would work. It's modeled on the Washington State model?
That's correct. It would recognize that there's, not all pedophiles are the same, but it recognizes that the dangerous pedophile, who's a psychopath, who's a sexual sadist, someone who cannot be rehabilitated, should never get out. And what this law does is that when a person's coming to the end of a sentence, you have a hearing to determine their dangerousness. And if as a result of that hearing, which is due process and you have to prove your case beyond a reasonable doubt, it's established that this person represents a real danger to the community, that person will be held indefinitely until such time that the medical authorities can be satisfied that this person no longer represents a threat to the community. But as long as the pedophile represents a threat to the community, he ought not to be out on the street.
So one would assume that someone like Bobby Oatway would fit into that category.
I must confess I don't know enough about his details other than what I just read in the newspaper, and that's not enough for me. I'd have to know more about his background. But certainly someone like a Joseph Fredericks, who's not just a pedophile, but is a psychopath and a sexual sadist, like a Clifford Olson. We know those people are extremely dangerous, and they should never see the light of day unless there's some breakthrough with medical science.
Yeah. Karen, you have a problem with that?
Well, I do have some problems with it, and indeed I think the way Tim has just presented it to your viewers is not exactly as it is in the Washington law. There would be an opportunity underneath the Washington law, which is what's being proposed, for a revisiting of the issue every year. There are built into the Washington law that mandatory treatment, which is something that I don't think is being focused upon enough by Corrections Canada, and I think that that would be a good area for the public at large to be focusing on. More of a recognition that it's an illness, that we're talking about civil confinement. We're not talking about jailing indefinitely. We're talking about treating them as opposed to imprisoning them, and that ought to be the focus, and I think that sort of rounds out what Tim is saying. So I have a problem with this suggestion that it's just jailing them indefinitely forever and ever.
No, we're not talking about jailing indefinitely. The Washington State is a model, but it's part of the criminal justice system to have it's preventative medicine too. It's not necessarily punitive. And the Supreme Court of Canada has already held in the context of indefinite detention that it's not necessarily punitive. It may be punitive for the offender. He may feel it's very punitive.
Right.
But if the law is drafted in a way that the pith and substance of the legislation is to prevent harm to the community, that is a responsibility that the federal government has to Canadians, and it ought to honor it.
But your law, does it propose they be held in jail or in a mental institution?
Well, actually, our proposal would be that you would have a particular facility that would be different than a regular jail. We are strong advocates of treatment. But just like people are advocates of treatment for cancer, you can try, but we know we have to be realistic that there isn't a solution yet for many kinds of cancer, and just as there is for psychopathy and pedophilia. So, no, we would keep it differently. It would not be a traditional jail setting, but it would be a maximum security setting, and we would hope that the treatment that would go towards these people would be real and tangible.
Right.
It's not a question of locking them up, and it's true, as part of our proposal, that there would be an annual review. In fact, after the first year, on the anniversary date of being determined to be a dangerous sexual predator, you have a jury trial to determine whether or not that designation should still apply. And so you have all the due process protections.
Laws, though, really?
We're going to have a difficult time doing it within our public purse. The right to a jury trial, the Washington model suggests that there has to be, if you're an indigent person without funds, the state has to provide you counsel. They also have to provide you with expert psychologists, psychiatrists to assist you in putting your position forward, and that should be done on a yearly basis. Right. With the situation with funding for crimes in the first instance now, the radical cuts that have been made to the legal aid plan in Ontario proper, and that are the cuts that are going throughout the country, I doubt very much, or I think it would be a very big impact on the public purse, and that's another consideration the public should be addressing their minds to. There's something else that's in the Washington model that Tim hasn't mentioned now. He's mentioned that he is an advocate of treatment. Arising out of the Stevenson inquest, I understand that there was a recommendation that the government focus on funds to research into this area, and I think that's another thing that ought to be done.
It hasn't happened. I mean,
no.
we did a show a couple of weeks ago on psychopathy, and with Dr. Hare, who's I would say is the world's foremost authority on psychopathy, and he twice has been said that funding was coming, has put together the team to do all the study, and twice it's been withheld. So
No, I think there's no question there has to be a commitment to funding. But let's put this in perspective. When we're dealing with the dangerous sexual predator, we're dealing with probably 0.5% of the entire criminal population. So from an expense point of view, let's put it in its perspective. I think the problem with this is, and where the government has failed, is that by failing to bring in a law such as this that targets the dangerous pedophile, the public, quite frankly, given the regime now, doesn't know the difference between a pedophile who's extremely dangerous and right down the continuum to someone who is still dangerous but isn't a Clifford Olson or a Joseph Fredericks. So I think what the government has to do to bring some integrity into this is bring in a dangerous sexual predator law so the public knows that the very dangerous pedophile, the psychopath, the sexual sadist is going to be locked up indefinitely unless there's some breakthrough on the treatment. Then you have to have a different kind of regime for the less dangerous pedophile, whether it's chemical intervention, making sure they're taking their medication, making sure they are being supervised. The problem is when the government does nothing, the public has no choice but not to make a distinction between the low-level pedophile to the extremely dangerous pedophile. They lump them all together, and then you get hysteria every time there's a problem. And the government has to...
And I want to talk about that hysteria aspect, but first I want to bring in some callers. Let's talk to Monica, who's calling from Ontario. Hi, Monica.
Hi. First of all, Jane, I'd like to say that I really enjoy your show and I watch it every day.
Thanks.
About pedophiles, I think they should be locked in jail indefinitely. Actually, I don't think they should be locked in jail because it costs taxpayers money. So I think they should have capital punishment. They should die. I have 2 boys myself, and I have an 11-year-old boy that goes downtown every day to school. And if something happened to one of my boys, I think if the justice wouldn't give them what they deserve, I would do it myself. And I feel sorry for whoever mother that lost their kids in a circumstance like that. That must be very painful, and my heart goes for them.
Okay, Monica, thanks for calling. Well, there are people who want capital punishment. We don't have it in this country. Let's talk to Joe, who's calling from Toronto. Hi, Joe.
Hi. I believe Corrections Canada would not have let this person out early if they had any inclination that the person wasn't rehabilitated. And you have to remember that our system is built on the basis of rehabilitation. And
hang on. He refused to have treatment while he was in there. He refused to have the treatment that would have dealt with the pedophilia.
Well, in that particular case, then he should be, then they shouldn't have let him out. So there's something wrong there. But
yeah.
Why shouldn't, on a general basis, why shouldn't pedophiles have the right to live where they please if they've done their time and have gone through the rehabilitation process?
And this is what you would argue, Karen, that you argued on behalf of your client.
Right. Well, my client was just dealing with bail breaches. I wasn't representing him on any sex-related charges. They were simply bail breaches. But the media blew it out of proportion in the same way that unless the distinction is made that Tim is suggesting that the public be made aware of, that it's only 0.5%, then what's going to happen is the public can get whipped up into a frenzy and a hysteria every time anyone that is released from prison that has a sex offense. And that's not where the hysteria needs to be directed, and it's not where the energies and it ought to be directed.
That's why you need the law in place to take care of the very dangerous ones so that the public can be educated as to know that the system is there to grab the extremely dangerous ones. The problem with warrant expiry, keeping someone into warrant expiry without a sexual predator law, is that if whether they let him out at 2/3 or let him out at the end, for the extra third he's going to get out anyways. And our concern is that even if you could be satisfied that the dangerous sexual predator was going to be kept till the full sentence, the warrant expiry, they're still going to open up the door and there's still going to be another victim.
And this is what Corrections Canada argues for letting them out, though, into halfway houses, that if you keep them to the end of the term, then they do walk open the door, and nobody has the right to know where they are. There's no controls on them, no treatment at all.
But that's absolutely right. But and that's another argument why, then, you must have a system where if those who can be rehabilitated and treated and work through the system identify who they are and put them through the system and make sure that the resources are there and the support systems are there to deal with them. Right now we have absolutely nothing. So therefore, by not making the distinction, another Joseph Fredericks will come to warrant expiry, or Clifford Olson, out he goes, and there will be another victim.
We have dangerous offender legislation. We don't have nothing.
Right.
Well, the problem...
There have been
and we
many
have
who
jury
argue
trials
that
in the first instance where you've got the input from Crown attorneys and defense lawyers, and you have a judge at the end of the day who determines whether or not the person ought to be declared a dangerous offender. Mistakes may be made. Tim. But you can't say to this public and to the viewing audience that there is nothing out there.
Well, if the problem with the dangerous offender legislation is that there's a very small window of opportunity within which to bring such an application. Fedricks is a classic example of a person where they wanted to bring a dangerous offender application. They couldn't prove the case because they had problems with one of the victims, and so they had to make a plea bargain, and that's the problem with the system. So if you miss...
You couldn't do a dangerous offender against Oatway now?
No, you have to do it at
No.
the time of sentence. At the time he's
Has to be
convicted.
then.
Yes.
And so that's the problem. There's a very small window of opportunity. The dangerous offender legislation is good legislation as far as it goes. The problem is that what we advocate is that children simply aren't expendable. And therefore, if you miss your opportunity, we don't sit back and say, well, you missed your opportunity, it's too bad, we have this thing called the Charter of Rights and Freedoms.
And a certain percentage are going to be killed.
Well, that's right. And that's unacceptable because the victim has as much charter rights as the accused, and we have to do the correct balance.
You're with Jane Hawtin Live. We'll be back.